Right now I'm standing in my backyard in front of a giant 65-foot yacht. A brand new yacht like this one costs $5.7 million. And today we're going to talk about how this company can protect that yacht. We're talking about LLC charging order protection. Hi, I'm the business guy with Asset Protection Planners, and today we're going to talk about a charging order and what that is. Charging order protection offers asset protection to members of LLCs and partners of limited partnerships. So first I'm going to talk about what the charging order is. I'm going to talk about the 5 best states in the country that offer charging order protection, even if you are the only member of the LLC. Then I'm going to talk about the best country in the world that offers LLC charging order protection that is superior to any state in the United States or any other country. And just to give you a little background, I've been in the asset protection field since 1991. Our company started in 1906. I believe we have over 70,000 clients in our database. We have licensed attorneys on our staff, and we are the largest asset protection firm nationally. And I need your help because for YouTube to promote this video, they want to know people like you like it. So if you could please click the like button below, I'd really appreciate it. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Okay, so let's talk about what charging order protection means. So let's say you are a member of a limited liability company, and let's say Wyoming, for example. Okay, so you own, that is, you're a member of a Wyoming LLC. Then somebody sues you. Not your business, but you're in a personal lawsuit. You rear end somebody in your car, and then you're sued for way more than your liability limits on your insurance. Happens every day. As a result, you can lose everything you own except for the things that are protected from that lawsuit. So we look at Wyoming Code Section 17-29-503, charging order, where it says, and I quote, "This section provides the exclusive remedy by which a person seeking to enforce a judgment," that means the person who sued you, "against a judgment debtor," and that means you, when you lose a lawsuit and have a judgment against you, you are a judgment debtor, "including any judgment debtor who may be the sole member." That means it protects your assets even if you are the only owner. Furthermore, it says other remedies, including foreclosure on the judgment debtor's limited liability interest, may not be ordered by the court. That's charging order protection. So the person who won the lawsuit against you cannot take your company away from you, and they cannot take anything inside of the company away from you. They cannot take away your company whether you are the only owner or just one of the owners. They cannot legally jump in and make management decisions on your behalf. The most that a judgment creditor could get out of the LLC would be if you were to make distributions of the profit from the LLC to yourself. So say you have a checking account in your Wyoming LLC. You write a check to yourself as a distribution of the profits. Then theoretically, the people who sued you would get that money. But here's something else. You are not required to make a distribution to yourself. They cannot force you to make a distribution. Plus, they cannot take your membership interest away from you, and they cannot jump in and become one of the managers of the LLC. And again, this is the case even if you're the only one who owns it. And single member charging order protection holds true in only 5 states. And that's Wyoming, Delaware, Nevada, South Dakota, and Alaska. In all the other states, you need to have 2 or more members in the LLC in order to enjoy charging order protection. So the charging order offers asset protection for the company itself, so nobody can take the company away from you or the assets held inside the LLC. Let's say you have $200,000 invested in a stock market portfolio. You wisely hold your investments not in your own name that could be gone in a flash, but you were smart and you hold your investments in an LLC. Okay, so let's say you're making 10% annually. You're in a mutual fund, so it's producing $20,000 per year on average. In this particular year, you made the $20,000. If you take it out and distribute it to yourself, it would theoretically go to your opponent. On the other hand, if you keep it in the LLC, that's perfectly fine. They can't force you to do anything else with it. And the true beauty is this. There's another booby-trap with the charging order protection, and that's Revenue Ruling 77-137. In other words, a revenue ruling that occurred in 1977, and it was the 137th ruling that year. It states that whoever has the right to receive the distributions of the profit from the LLC, that is, the one who has the income rights from tax flow-through entities such as an LLC or limited partnership, needs to pay the taxes on the profit that LLC makes on that member's interest in the LLC, whether they receive the profit or not. So in other words, you as the member of the LLC decide not to distribute the profits that would be paid to these other people. However, they still have to pay the taxes even though it remains in your company. Some more recent decisions have softened that blow in some cases. Okay now, so in other states besides Nevada, Wyoming, and these other states, you need to have 2 or more members in order to enjoy that protection. If there's only one member, let's say in California, Florida, New York, Texas, they would theoretically get the charging order and then foreclose on your interest and take the company and its assets. So in other U.S. jurisdictions besides those 5 states, you need to have 2 or more members to enjoy the charging order protection. Okay. So how long does a charging order last? In the U.S., 20 years. A judgment lasts for 10 years and can be renewed for another 10. During that time, you can get the money out in other ways. Instead of paying a distribution, why not pay yourself a salary or pay a trusted friend or relative? They can buy you the things you need, such as help you with your mortgage payment or buy your groceries. So there are some tricks to getting the money out of the LLC without the LLC's income being subject to your judgment creditor. Now let's kick it up a notch. There's another jurisdiction that offers far superior protection. And this is a place where we have established thousands of LLCs. In fact, we have established more LLCs than anyone on the planet. That is the Caribbean island of Nevis. A Nevis LLC is the LLC that offers the best charging order protection on the globe. I've been to Nevis many times. I know 2 of the last 3 premiers of Nevis, as you can see on our websites. And in the 30 years I've been in this business, I've done tremendous research. I've probably written more asset protection articles than anybody on the planet. And I've never seen any LLC anywhere that offers more protection than the one offered on this island that sits off the southeast tip of Florida in the Caribbean Sea. It offers the strongest asset protection of any LLC. In Nevis, in order to even get a charging order, your opponent would have to fly there. He or she would have to post a bond that could be $100,000 or whatever the court decides. They could set the bond at $400,000 that your opponent would have to pay before filing suit to get a charging order against your interest in the LLC. So say they tried to accuse you of fraudulently conveying assets to the LLC after somebody had a legal claim against you. Fraudulent conveyance is a civil matter, by the way, and not a criminal one. When you add the word conveyance to that word, it just means you tried to keep your assets away from somebody who got a judgment against you. First, in Nevis, you have even more powerful charging order protection there, and I'll tell you how. Again, you have single member LLC charging order protection. Your creditor must post this huge bond before they can sue you for your LLC membership interest. Then, if they try to accuse you of moving your assets into the LLC with the intent to keep it away from a judgment, they have to try to prove that you did so, not just by a preponderance of the evidence, say 51% to 49%, but they have to prove their case beyond a reasonable doubt. So that is more like a 97% to 3%, a pretty high bar to hurdle. So first, the courts can force the creditor to post a bond in the hundreds of thousands of dollars. Then they have to face a nearly insurmountable task of trying to prove their case to such a high level that it would be unlikely for them to prove in most cases. And the true beauty is, even if they did thread that needle with a rope, their charging order does not drop off in 20 years like it does in the US, but in 3 years, and it cannot be renewed. And the protection is even better when an offshore trust in Nevis or the Cook Islands owns the Nevis LLC. Because in that case, any charging order at all would be almost impossible. Plus, you would not have to worry about a results-oriented U.S. judge telling you that since you control the LLC, he's going to throw away all the other laws and make you turn the money over anyway. This is because when an offshore trust owns your LLC, our offshore law firm can step in to protect you when you need it, and a local judge does not have jurisdiction over our foreign law firm. So that's what charging order protection can do for you. So whether you have a $100,000 rental property, a $500,000 stock market portfolio, or a $5.7 million yacht, that is how an LLC can protect you from having a judgment creditor rip the rug out from underneath you. So that's the charging order protection. Please click like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy.